Well, welcome back to the TuckerAllen virtual town hall. I'm your moderator, Scott Trout, and I'm likewise joined by the attorneys of TuckerAllen. And today we're going to talk about and break down really, I think, is maybe a large misconception about how you understand and avoid probate and what elements actually do avoid probate. And really, we can break that down into simple terms because I do see that and as we've been doing this for quite some time, you see some of the assumptions that are made that if you do one thing, that'll avoid probate, or if you don't do this, it'll avoid probate. So we'll break that down in simple terms, and obviously in the second half here today. Once we're finished with some of those topics, we'll take your questions. You can submit those via the Q&A section right here during our session, and we'll get to those. Otherwise, you can submit them via email, tuckerallen.com/questions. And we can get to those in other podcasts or our Facebook Live segment. If you haven't watched or joined on Fridays at 1 o'clock Central Time, 10-15 minutes, really quickly. You can join in. It's free, obviously. You just go to Facebook, TuckerAllen's Facebook page, and you can join us on Friday where we just address spot issues just like today. So again, we'll be addressing some of your questions in the second half. You can submit those in the Q&A section, and I'll be monitoring that as well. And so also give us a call. If you want to schedule a consultation, we have offices throughout the state in Missouri and Kansas City, St. Louis, and over across in Illinois, 866-335-3375, or rather than making a call, you can just go to the website, TuckerAllen.com, and you can schedule a consultation right from the convenience of your home on a computer, and it'll give you some of the options to schedule as well. Keep in mind, obviously, we can't give you legal advice. This is something that is just educational and informational. I always talk about that because it's important to understand that nothing can really replace a consultation with an attorney that practices in the area of estate planning like the attorneys at TuckerAllen do. So joining us again today are the two attorneys over at TuckerAllen, Kevin and Jim. Welcome, gentlemen, back to the program.
Thanks for having us.
Thank you, Scott.
Great. Well, we're going to talk a little bit about understanding probate, trying to break down. One of the goals of doing this is to take the terms that lawyers throw about, easily, because we understand them. It's kind of our language, break it down into easy, understandable items for the public so that they can take action. But before we get started, again, remember, you can submit your questions now. We'll be monitoring the Q&A section. But before we get started, we're going to take a very, very quick commercial break. We'll be right back.
Strong roots are essential for a healthy tree, especially your family tree. That's why you work hard to take care of your family every day. At TuckerAllen, we know that taking care of your family means planning for the future. Our team provides personalized estate planning to help ensure that your family and your legacy are protected and that your future is secure. From wills and trusts to long-term care and estate planning, count on TuckerAllen, personalized estate planning made simple.
All right, welcome back. Let's get started right away. Again, Q&A section. We've got some questions we'll be addressing here shortly as we get through some of the misconceptions. And Kevin, I want to start right away with you. I think this is the big one, and I hear it a lot, even with friends and even family, where they've said to me, "Oh, I'm good. We've got a will." And that's a real clear misunderstanding of that will avoid probate, they think. And I guess the question is, does it avoid probate if you just have a will?
Sure. So a will does not avoid probate. A will actually is guaranteeing that you will be going through the probate process because a will must be probated. And so I think, like you're saying, that's an incredibly common misunderstanding that people have. I hear it pretty often in consultations, meeting with people where they say, "Oh, well, let's just get a will. I want to avoid probate." And I have to say, hang on, a will does not avoid probate whatsoever.
So, we talk about the word probate, and I know that the word estate is also thrown about. And probate, maybe let's talk. I've heard people say, "Oh, I'm going to a probate lawyer." And I want to ask you a question about estate in a minute, or maybe throughout the misconception of estate. But what does probate mean from a lawyer's perspective or a court's perspective?
Sure. So probate is just a term that, it describes the process in which a will is reviewed by the court, and then they are determining its authenticity and whether it's valid or not. And so that's kind of what the probate process is, or what probate means.
And they have a particular probate court in many counties, whether Missouri, Illinois, the judges just handle those I guess we'll get to a trust, but the ones that just either don't have a will or just a will, they just handle those, right? It's called the probate court.
Yep. So yes, it is called the probate court. And then what the role in that court, what they're doing is they are just looking at the wills, determining whether it's valid. If it's valid, then they're going to walk through the process of making sure that the assets are distributed as they should be in accordance with that will.
So, and I know I want to talk a little bit more about the will and kind of the purpose behind it, but I always like to talk about the word estate.
Mhm.
You know, even TuckerAllen in the ad that you have, it talks about estate planning attorneys or estate planning made simple. And people, I think, confuse that, especially maybe a younger generation, that estate meaning I have to have a lot of stuff. I mean, I have to have a lot of property, or I have to have a piece of real estate in order to take the steps to protect myself and just drafting a will. That's just not true, right?
No, not at all. So the term estate, all that means is just all of your assets. That's all that we're talking about. And estate doesn't mean real property, or it doesn't mean that you have a whole bunch of assets. It just means all of your assets, whatever they may be, whether it's as small as, just a checking and savings account, or whether it's as large as somebody who has multiple pieces of real property and 4 vehicles and 2 boats. An estate encompasses both of those 2 people.
So let's talk about the will.
Mm-hmm.
So would you agree or say that a will is more like kind of an instruction manual, that absent no will, it tells the court what you want done with your stuff?
Yep, that's a great way to think about it, is that will is that instruction sheet to the probate judge telling them how you want your estate or, your property distributed after your death.
So in the easiest thing, I know that oftentimes you'll say, look, will is a great first start, or powers of attorney, whether it's healthcare or financial, it's a great start. But it also, you'll talk about doing a trust and why that's important as well. We'll talk about that in a moment. But the will also, in the instruction sheet, will nominate, designate, appoint, instruct someone that you trust to help distribute your things or take care of what's left behind to make sure it goes to who you want it to go, right?
Yes, it does. So what that will is doing is, what that role that you were talking about there is either, it depends on, it's called a personal representative or the executor. They mean the same thing. They're doing the same job. It's just people use the terms interchangeably for whatever reason. But that's someone, and what you're doing is you're creating a relationship with that person between your personal representative, and then they're going to have a relationship with the court. So the court is kind of monitoring your personal representative to make sure that they're doing what your will instructs them to do.
So if we take, someone doesn't take that first step and they don't create the will, I imagine there is still an instruction sheet. Every state may have it, whether they call it a statute or a code or some other formal process by which now your personal wishes aren't followed, but the instruction sheet is followed. So what is that in Missouri?
Sure. So, yep, every state, regardless of either, you have 2 options. Everyone does. Either you can create your own estate plan, or the state in which you live is going to create an estate plan for you. Here in Missouri, it's statutory. It's set out in our revised statutes. Like Chapter 474 is what lines it out. But it's not something, whenever the state's the one that is drafting your estate plan for you, that it might not be what you want it to be. And it also just creates a much larger hassle because there is no personal representative that has been named. So someone, a spouse, a child, someone is going to have to try to get nominated by the court into that position. And if maybe there's 2 people that want to be nominated into that position, and then, now there's a little bit of a legal battle going on as to who's going to be the personal representative. So, probate is always a time consuming and a little bit just messy of a process because it is, the court is overseeing it, but whenever it's intestate, it's even more so.
I think you make a good point in that how messy it gets, especially maybe arguments may ensue simply by having this instruction sheet. Again, take the first step with a will, albeit it's not probably a complete plan that you would recommend, but at least it avoids, there's stress when someone passes away already. The point is you want to avoid siblings, relatives, friends from arguing about where your things should go, who should, process it and handle it. And just take that first step and say, okay, in the event that I pass, here's how I want it to go. It's a breath of fresh air for the people left behind to know that what you wanted done, we're going to follow exactly to the T. And that avoids that messiness. I think it's a great point that you suggest in terms of that instruction sheet.
Mm-hmm. Yeah, it's the ease of which an estate is distributed with a will versus without a will is just incredibly significant. So always at least take the first step and get some sort of a will drafted up for yourself.
So if you have questions along the way, again, I'll be looking in the Q&A section. Make sure you put those there. We'll be answering a few of them that we have already in just a few moments here. But Jim, so we have another word or words that are tossed about are trust administration. Again, you would think that we could make much easier words to understand and not have to continuously do virtual town halls to break it down because it gets so confusing. So what's the difference between probate and trust administration?
Yeah, so probate, again, we've got all these different words thrown around. We've got probate, we've got probate estate, we've got estate, we have taxable estate, non-taxable estate. And so the probate court actually handles anything relating to a guardianship, a conservatorship, and those can be avoided by powers of attorney. So if you've got powers of attorney, even simpler documents than a will or a trust, that keeps you out of the probate court, but just by having powers of attorney, and that's while you're alive. So those documents to me are the most important in an estate plan, besides the will and the trust, because it deals with you, not just your stuff. But the probate court, the difference between the probate and trust administration is the probate court handles it when somebody dies. And so we'll administer the will or present the will to probate and ask that it's admitted. And like Kevin said, that's just checking the validity of the will, whether it was executed properly. And then, the court, if you don't have a will, has to nominate like Kevin said, the executor, the personal representative. And if there's not a will, it's most likely going to be, costs then incurred and getting a bond and making sure the right person is the personal representative, because if there's multiple children, they all have an equal priority to be that executor. And so we'll go more in depth in the probate process, kind of itemized here in a minute. I believe Kevin will handle that. But basically the probate process, getting stuff transferred versus trust administration, it's open, it's public, everything's filed, can be looked up on CaseNet. We have to publish a notice to creditors in the paper, and it stays open for 6 months and allows them to make claims. Not only that, but since it's in a court already, I've seen beneficiaries are much more likely to kind of raise concerns or raise challenges because it's already in. Everybody thinks of court as kind of a forum where they can make arguments. It's more argumentative than trust administration, which is completely outside of the court unless there's a challenge or a case filed. And so trust administration is private. It's a lot quicker. We have the option to publish a notice to creditors, and it's beneficial most times because it speeds up, it shortens the statute of limitations on claims that can be made. So there probably would still be a publication. But other than that, there's no public records in a court. It's all just it's almost a contractual arrangement between a contractual fiduciary relationship between the trustee, then who you name, and the beneficiaries who, you also choose. And it could be, just as simple as getting tax IDs for the trust and distributing the assets out, or depending on the terms of the trust, it could be held for a much longer time, depending on the family.
So in the trust administration, I guess that's step 2, and that is the way to secure your way out of probate, where you mentioned here, it's a private process that between the trustee and the beneficiaries, and it's not as messy in court. And everybody, I think, wants to avoid court intervention. I wouldn't want the court, telling my beneficiaries or telling my heirs what they should get. That's the point, is avoiding probate by taking a will, and then that second process, right? And that's where you get to the trust administration by doing the trust with the will?
Yeah, so you would have, when you've got a trust plan or an estate plan that focuses on a trust and is centered around a trust doing the heavy lifting, you will also have a last will and testament. We call that more terms. We call it the pour over will in that case, meaning that you've got your trust and then the will pours over anything into the trust that may not have been designated to go to the trust, whether that be owned by the trust, actually titled in the name of the trust during your life, or appointed to the trust by beneficiary designation at your death. And so anything that doesn't have a valid beneficiary designation has to go through probate. And then the will says, hey, judge, put all my stuff in my trust, pour it over into there so that nothing circumvents the terms of that trust.
I think you, going back a bit, you wanted to make a comment. You made a good point about probate. And it's not just for matters after death. You mentioned guardianship, and it can be avoided by simply doing powers of attorney. And I know I alluded to that with Kevin, and that's a key way to avoid guardianship while you're living in the event of a disability, isn't it?
Oh, absolutely. Yeah. The powers of attorney, like I said, I consider those some of the most important documents in the estate plan, if not the most important documents in the estate plan, because it is, you're alive, you're not able to make your own decisions. And so you need someone to manage and talk to the doctors even, and make financial decisions, keep paying your bills during your life. And so, yeah, absolutely. Those would avoid. So instead of someone having to go out and get a court order saying that you have authority to act on behalf of this person, they have a signed, notarized document naming them as the agent for the person that executed those documents.
Mm-hmm. And they're easy. I mean, that's the wonderful thing on the POAs. And we're doing a POA campaign for college students, I know, this summer. And everyone thinks, oh, power of attorney, you have to be older, you have to be acquiring stuff, you have to be whatever, middle-aged. It happens. And I've said this in previous virtual town halls, and I have 5 kids and guilty as charged. I mean, my older ones, I didn't do POAs and they should have. It's as simple as being able to help them transact. In the event that they get injured, you're designated. I mean, that's where I think your point is right on. It's some of the most important documents. I know we mentioned the will, step 1, but maybe 1A or before step A is the POAs. Get those done. If you can't do anything else, get the POAs done. The healthcare power of attorneys, financial, get it all set. A couple $100 done, right?
Right. Yeah. So if you're looking at kind of if you can picture in your head an estate planning pyramid of needs, at the foundation of that pyramid is always going to be powers of attorney for healthcare, finances, living will saying your end of life decision and wishes for life support, a HIPAA release, which is very simple, and then the will and the trust. Those are usually the foundation for 90% of people. And then once you move up the pyramid, it gets more complex, but normally most people stop there, actually.
So, Kevin, let's talk about the probate process. I know maybe someone's watching and they don't know where to turn or what does that mean. Maybe it's enough if you talk about this process to convince them that they never want to go through this process because, one, lawyers make more money and it's by statute. But maybe walk through the process and what happens in probate.
Sure. So I'm just going to give 6 kind of quick high-level steps here. So the first step in any probate process is that you have to file a petition to begin the probate. And what that means is that you have to file this petition within the court, or the probate court in the county where the deceased person lived at the time of their death. So you submit the original will, you petition the court to open the probate there. Then our next step is going to be giving notice, which Jim had talked about just a second ago. So we have to give notice. One way to do that, you can just publish in a newspaper. So you have to do that for the potential creditors whenever you do a probate estate. Then the next step is that the personal representative, whoever that is, they need to inventory all the assets. So they need to collect all the assets, inventory them, and kind of get a rough appraisal of how much they're worth. And then what you do is you present that to the court and allow the court to, kind of double check your work a little bit and just make sure that it all looks correct. Then at that point, the next step 4 here is you're going to pay, debts if those creditors do show up after you you give notice and some creditors show up, you may have to pay debts. There may be some bills that need to be paid as well. So then at that point, you could do that. Then finally, step 5 is the step that everyone cares about, which is where you can distribute those assets to the beneficiaries. And so that's all the way down at step 5. And then the final step is just closing the probate estate. So you go back to court, you submit the receipts and the records of everything that you've done to the court, and then you just ask them to close the estate, and they'll kind of, again, check over everything one last time, and then they'll grant you the closing of the estate and release you from your role as the personal representative.
It's enough to just listen to the 6 points to realize that I don't ever want to be part of that. And I've always tried to come up with examples to simplify the importance of something like this. And that, look, we spend more time routinely getting our oil changed in our car, and maybe it costs us $39. And why do we do it? Because we don't want to incur costs in the future to have major repairs. We don't have to want to go to the auto body shop or whatever it may be. But yet, when everything is on the line in terms of the things that you've acquired, your kids and who's going to watch them and who's going to care for them, and maybe if you have special needs kids and how that's going to happen, we delay it and we don't take the right steps. And here we're talking about these 6 crazy steps in 12 to 15 months for probate to take place. And that's why if you just think about the daily activities that we do, and the reason we do them is because we've been told that we need to do them. I mean, from the time that we're 16 years old, we have a car to drive, we're told you got to put air in the tires. You got to make sure the oil's changed. Washer fluid, go clean your car. It's crazy. And I think this, what we're doing this virtual town hall is simple message, simple estate planning. And it takes care of it, and it's a peace of mind. So, and what are the problems associated with probate?
Well, the largest problem, or the 2 largest problems, are probably, one, the amount of time that it takes. So it is, you're required to wait 6 months after notice for potential creditors to come forward. So, I guess potentially you could get it all done within 6 months, like theoretically. That just never happens. So it's almost all the time, it's going to take somewhere between, 12-ish to 15 months, depending on if it's very complex or if there are some disputes, then it could definitely extend past that 15-month period. And it also kind of depends on who you choose as your personal representative. If your personal representative is on the ball and they're getting stuff done on time, then, that can lower it a little bit. But at the end of the day, it's kind of in the hands of the court and how fast they can move. And here recently, a lot of probate courts were not moving quickly at all. I know here in Jackson County, it was moving incredibly slow. So I think for a while there, it was going to be more like 20 months to get through the probate process out here. So that's the one big problem, is it takes a long time. The second big problem is that it requires an attorney a lot of the time here in the state of Missouri. And there's a statutory fee that goes along with that for an attorney to go through that process with you. So it just costs money, again, just on that end. So,
Jim, what are you seeing in terms of the creditors or the process or fights among family members? Are those some of the things you're seeing?
Yeah, like kind of like I mentioned earlier, is that we're in this probate court. We're in a courthouse, which is already high tension. And we're there for, 6 months minimum, but realistically, like Kevin said, 12, 20, 24 months, depending on the executor or personal representative and how fast everything's going. And also, we've provided notice to the creditors, so they have an opportunity to come out, make their claims. And these smaller creditors will make claims, but they have no intention of actually collecting. So there's, we see it in almost every estate. There's an $800, a hospital bill, or a small credit card of $1,000, something like that. Normal everyday debts that people have. And these creditors will make a claim against the estate, but their process to follow is they have to make a claim. The attorney then calls it for hearing. And most of the time, $800 to get an attorney from Citibank or MasterCard to come out and actually show up for a hearing in St. Louis County or Jackson County or Boone County, Callaway, those Missouri counties, it's just not going to happen. So The attorney, we still have to go out and sit there for an hour, a couple hours, and bill hourly. And the whole time, the creditor is not going to show up, and they know they're not going to show up, but they're not just going to dismiss it. And so that's kind of the biggest headache on our end, other than the, typical horror stories of probate, of family fights and things like that. But it's just those procedural things that we have to do that are just time consuming.
Yeah. I mean, the last thing you want are all those things to happen when you're gone. Just make it smooth, make it easy, wrap it up, be done. There are issues, obviously, even with the trust in terms of timing and getting things processed. But it's just, streamlining the process and making it easiest for those that are still behind.
Right.
That's kind of the focus, I think. And again, I'm thinking of there was a show called Scared Straight about not going to prison for kids, right? And if we're not scaring you enough to say, okay, I don't want this, I got to have a will, I got to have a POA, I got to have a trust, best time you'll ever spend and best money invested you'll ever have to ensure that this doesn't happen. What are the costs typically, Kevin, for an attorney if you don't have a trust and you have to go through probate?
Sure. So our fees as the attorney, they're statutory again, so they're just laid out by the state of Missouri what we're going to charge you. And again, sometimes it may end up though that we are going to be charging more than even just what the statutory fee is, because there's going to be extra work on the ancillary to this probate estate that we're going to be doing for you as well, whether that's like an affidavit of death to move a home into one person's name solely, or whatever it is. It's a little bit of work there, other than just showing up to the probate court, dealing with potential creditors and things like that. So, and more than just our fees, there's other fees as well that are associated with probate. So there's the filing fee, for filing things different. There's things that need to be filed, such as the original will. We have to file a petition. So there's filing fees. Sometimes a bond may be required for the probate process. Hopefully your will says no bond is required, but maybe, you pass away intestate, there's going to be a bond that's required. So there's a lot of kind of ticky-tack fees associated with probate on the back end, as well as kind of that bigger fee, which is the attorney's fee. And generally speaking, those are going to be, depending on the size of the estate and what all is going on, that's going to be statutorily probably going to be anywhere from like 4% to 10% of the total estate is what it's going to cost. And that's a pretty good chunk of money, so just to think about it in like even numbers here. Let's say somebody has an estate that's worth $100,000, and that's really not out of the realm of possibilities for most people at all. By the time you're talking about maybe they have a retirement account and their home, that can eclipse $100,000 really fast. But let's just say for the sake of this that it's $100,000 even, and we have to probate these assets that are all worth $100,000, and it's only $4,000. We only are going to take the 4% statutory fee is all that this one is. That's still $4,000. I'm sorry, the 10% fee would be $4,000 that we would pull from that. Whereas the cost of a trust, is only going to be somewhere between $2,000 and $2,500. So you're still going to be saving money on the back end on that.
I think it's a matter of understanding that if you've got things to be, given, you're going to spend money one way or the other, and whether that's through an attorney and in a process that makes you rest easy and knowing it's all handled, or you leave it up to the court system and spend more money with a lawyer. So I know that's a tough pill to swallow, but the process of drafting, designing the instruction sheet, which is the will and the trust, is so much more affordable in the long run. It sounds that really is the way to go.
Right. Yeah, I got my math screwed up there. If it was 10%, that would be $10,000 that we would be talking about, where the 4%, the bottom number, is the $4,000, which is still more than what it costs to get a trust to avoid probate. So, and there's a lot of people out there who their probate estates are going to be much larger than $100,000. So that number only gets amplified.
I think what's nice is on your website, you list the fees and be very transparent for trusts, wills, POAs. It's all there at TuckerAllen.com.
Yep, absolutely. It's all right there, and it's very transparent what we're charging.
Great. All right, let's get to some of the questions, and then we'll wrap it up. If you have a question as we're going through what we have already, you can submit those in the Q&A section right now. We'll get to those with a few minutes that we have left. So, Kevin, the first question is, does opening or maintaining your accounts with a POD designation avoid probate? So maybe first mention what POD is, and then does it avoid probate?
Sure. So what POD stands for is payable upon death or payable on death. And that's generally used for like bank accounts is what we're thinking of whenever we say POD. A POD designation will avoid probate. Absolutely. It's not going to go through probate if you have the POD designation on there, but there are some kind of pitfalls that people need to be aware of with POD designation. So just yesterday, I was talking to a guy over here that I work with quite a bit. He's a financial advisor, and he was talking to me about how he has all these clients that they get their PODs set up, where it's going to a spouse or a child or something. And he said, a lot of times, like it's a spouse, maybe it's a second marriage, he said, and the spouse passes away and they just never change the POD designation on their document there. So then now we have the issue where the person who it's supposed to be going to has already passed away. And so there's a lot of potential pitfalls with using just kind of the POD. You really have to be up on it and organized and stay abreast of what's going on. And if you're doing all those things, then it's a great tool. If you're not really somebody who's super organized and really stays up on things, then I would kind of hedge maybe more towards like the idea of, hey, let's have a trust. And then you can just make this asset POD to the trust. The trust isn't going to die. We can amend the trust all we want. We can do all these things. So that's kind of how I think about it.
Along those lines, similarly, Jim, all of my assets in my house are TOD/POD. I'll have you talk about what POD is too, or TOD, to my 2 adult children. I have a will. I was told by a real estate agent friend that I still need a trust. Do I need a trust and a will? And I know we talked a little bit about that earlier. So all of the assets are TOD, POD to the 2 kids. They have a will. Real estate said I need a trust. Do I?
Yeah. So let's there's a lot to unpack in this question. So the TOD is a transfer on death. And normally that's going to apply to, like Kevin said, the payable upon death is usually financial accounts, bank accounts, mostly checking, savings. And then beneficiary designations are usually brokerage and retirement and life insurance. And then TOD, transfer on death, is normally what you see on like a car title. And so all the same thing, just called something different. Just everybody wants to be unique. The banks, the DMV, the life insurance companies. And so the way I kind of rank the quality of probate or non-probate transfers of getting assets to who you want it to go to is top is obviously going to be a trust. And so the trust, you can designate who you want the assets to go to, and you can also put terms on those assets as far as, whether it's I'm controlling for a special needs beneficiary or someone that maybe isn't good with money, or I've got a lot of young kids or young grandkids that I want to get money, and we don't obviously want a minor, a 5-year-old running around with $100,000. And then you can also do it for asset protection. So you can actually set it up so it's completely flexible and able to be used by the beneficiaries, by your children, and they're in charge of it. But it's asset protected if they get sued or divorced, because it's technically trust assets, not their assets. So that's why the trust is top for me. The second would be a POD, TOD beneficiary designation. The issue with those, yes, they avoid probate. Great. If that's your only goal, then absolutely a POD, TOD beneficiary setup would work. You have to make sure that it's on all of them, all of your accounts and all of your assets, but they'll avoid probate. The problem is it goes straight to your children, straight to your beneficiaries. They take the check, they put it in the bank account that they share with their husband or wife, and then they get divorced. And you've commingled the assets, and now you've potentially lost, half of your inheritance just by depositing a check that you thought was perfectly acceptable. And then the will is the lowest, which that's because it has to go through probate. And so that's the lowest. That's, it's kind of our backup plan catch-all. So if you have a trust, you still have a will, like I mentioned, the pour over will. If you have beneficiary designations designated, you still want a will in case you missed the Santa saver or vacation saver accounts that everyone forgets to put a beneficiary on. And so, long answer, the trust is the best setup you can do. If your goal is just to avoid probate, the POD beneficiaries setup will be fine. And
great. And a similar question, Kevin, and I know maybe have answered, but it was asked, if I structure all my assets with a TOD, POD, or named a beneficiary, why do I still need a trust if the trust has no assets in it? And that's always a secondary question about funding the trust. But if they've done everything, then what's the point of the trust?
Well, I think just like what Jim was talking about there, right? Divorces, they occur. Sometimes people don't get along with their son or daughter-in-law. A trust is a great tool to make sure that that money is only going to go exactly where you want it to go. And then the other thing is with the trust, again, right? And every trust that Jim and I draft, we put in contingent language there to say, okay, if this primary beneficiary passes away, this is what we want happening to their share, or, we have a backup plan within this trust for whatever's going to occur. Whereas with the TOD designation, you can't create a backup plan with the beneficiary designation or a TOD or a POD. There is no backup plan. So that's one reason why, or two reasons, I guess, why trusts are very useful right there.
And I think it's interesting to mention that with these questions, when they submit it, say, I've done everything in TOD or POD, it makes the assumption that their asset and property acquisition is static, that nothing is acquired. I mean, that's a huge point, because as we change cars, we change homes, we acquire whatever it is, different assets, stocks, mutual funds, whatever, valuable property. And it's great that you took action 2 years ago, 5 years ago, but what's changed? I mean, that brings up the legacy protection program that we've always talked about. I always like to plug that you guys have that, which I think is a wonderful item. And that is where for a small amount of money, you get an annual checkup, just like we said on your vehicle. It's making sure everything's working right, everything's planned right, everything's vested or put into the trust and funded correctly. If you've acquired something, you all take care of that in the legacy protection program. So you can talk briefly about that, Kevin, and then I think we're finished with all the questions.
Yeah, absolutely. So the legacy protection program, it's great. Like you were saying, it allows us to have that annual review where we can sit down, look over the highlights of the trust. We have a few simple questions we want to ask. Has anybody been born? Has anyone died? Has anyone got divorced? So we have some simple questions to ask. If people are going to respond yes to those questions, then hey, we're going to say, let's make some changes here as you would like. And then also those minor changes that you were talking about too, where it's maybe instead of, maybe somebody did pass away and they were one of your agents on your POAs. You know what, let's go ahead and get them out of there and let's put somebody else in. And those are things that we can take care of really easily, especially whenever you're a part of that legacy protection program.
Yeah, I think it's really a key thing. You don't have to be a previous TuckerAllen client. You can find out more information on the website, TuckerAllen.com. You can sign up for that legacy protection program, even if you had someone else drafted. They'll take a look at what's going on, make recommendations, if any. Sometimes it's good to go, but it's always good to take it off the shelf, wipe the dust off and have them take a peek and make sure. We know we have Biden administration getting ready to change some of the rules, we presume, with regards to the death tax and the estate limits. So maybe that you want to get that taken care of if that changes. So gentlemen, thanks for joining today on the virtual town hall to talk about probate.
Thank you, Scott.
Appreciate it. So check us out, TuckerAllen.com. You can follow us on social media as well. And don't forget, on Fridays, 1:00 Central Time, 10-15 minutes, we go live on Facebook. You can ask questions in the comment section, and just we'll take a spot issue for 10 minutes, try to break it down. And again, like we say, make estate planning simple for you. So until next time, thanks for joining and have a great week.